today we're going to be delving into professional letter writing by counsellors when we need to write to a fellow professional.
Yes, as a supervisor, one of the things I picked up through the years is that some of the people I work with struggled with letter writing because it was never taught in first trainings. When people go into private practice, they find themselves having to communicate with other professionals. And as such, they have to write letters. And I'll give you some examples of the letters that sometimes a counsellor has to write. Things like referral letters, communicating with doctors, psychiatrists, or other professionals regarding the client's mental and emotional health needs. Collaboration letters. So for those who work in schools, this could be updating social workers or other support networks with the client's consent. When we're working with children, it's worth considering that maybe a lot of other professionals involved. It might not just be counselling, it could be social worker, there could be a legal aspect to it. And then finally, report writing. Sometimes we have to write reports for legal cases, insurance claims, or employment support. So when we think about letter writing, as a supervisor, I've been called in quite often to give my opinion. Is the tone right? Am I giving too much information away? Again, not something that's taught in first trainings, but really it's not unusual for a therapist who's working privately. And it is a very nuanced and thoughtful approach that's needed with letters, because you've got to communicate what's being said correctly and any outcome you expect from the person you're writing to, realizing, of course, that the letter can be seen under data protection regulations by the client.
There is a lot to consider, and we're going to walk you through some areas that you might think about when writing that professional letter. When we think of letter writing, I might think, oh, write a letter, that's easy. But as you've already mentioned, Rory, these letters are professional documents. They may go on record, often do go on record, and it will be called upon at a later stage if needed. There may be legal reasons to call upon the letter that is written. So they are important documents, but I want to share the day I realized just how important these documents are. I was in a multidisciplinary hearing meeting, so a number of different professionals from different disciplines were gathered together. I was working in drugs and alcohol recovery at that time, and the meeting was about taking away this person's children. And the outcome of this meeting was that person kept their children. And the weight that tipped it over was a letter from the counsellor that was working with this person that showed that this person was committed, was working hard, was doing what they needed to do, was arriving on time at appointments. And think of the value of that letter. When you're called on to write a letter, they are important documents. That's what I'm trying to really emphasize here, Rory.
Yeah, absolutely, Ken. We never quite know the impact the letter is going to have. Or the email, it could be an email, but usually if you're asked for professional communication, they usually want it in letter form. The other thing I was thinking about, Ken, was that if you are a supervisor whose supervisor has gone through a disciplinary process with the ethical body or the professional body and been sanctioned, you will have to write to the ethical body saying that they've exercised the sanction. You might have to write to the professional body saying they have attended and made good progress within extended supervision and have a more nuanced approach to the difficulty that got them into trouble in the first place. So there's lots of areas of report writing, and especially things like child protection. I wrote a fair few when I was a school counsellor to different professionals. But the balance is, what do you share? If you're talking about a client, that's the crux of the matter. And I think when you think about something called the Caldicott Principles, and they came into being because of a terrible incident of a child who was murdered, I think, by their uncle. And it turned out that professionals hadn't communicated to each other because they were worried about data protection. They were frightened about data protection. And what happened was they came out with initially, I think it was 6 principles and then 7 principles. And the first one, we probably won't go through all of them, but the first one is justify the purpose for using confidential information. So if you have to share confidential information to a third party about a client, what you need to do is you have to be able to justify why you've shared it. If it's about harm to self or harm to others, a lot of private practitioners have that in their contracting, then you can justify it. The client understood the limits of confidentiality. They disclosed some information which went against the limits or collided with them, and you believe there was clear and present danger to that client, and you thought you needed to disclose that to their GP. And that's really the first position. The Caldicott Principles are really important. And another one is don't use personal confidential data unless it's absolutely necessary. And these 7 principles will be something that you'll be held accountable to should someone make a complaint about you about sharing data. It's really important that anybody who shares data has a solid understanding of the Caldicott Principles.
It's interesting, Rory, how it's not taught, or it wasn't during our time of tutoring taught at any great depth. It wasn't part of the curriculum. Maybe it is today. I hope it is. But I can share this with you. If you did step outside of the Caldicott Principles in a letter that was later called upon and maybe a complaint was levied, you would be asked why you did what you did. And sticking to Caldicott Principles kind of protects you, but more importantly, it protects the client. Rory's gone through number 1, justify the purpose, and number 2, don't use personal confidential data unless it is absolutely necessary. You include what is necessary, only what is necessary to get the message over. Principle 4 is access to personal confidential data should be on a strict need-to-know basis. Principle 5, everyone with access to personal confidential data should be aware of their responsibilities. Number 6 is comply with the law. And number 7, the duty to share information can be as important as the duty to protect patient confidentiality. That's an interesting one, Rory. And just one last thing I want to put in, Rory, is when you're writing a letter or you're completing a document for a client or for a supervisee, you put in that is factual, not what you feel or what you surmise or what you think. Just stick to what is factual, and a very good reason for that. First of all, we're able to defend it. As Rory said, justify the purpose. So if we broke confidentiality and said this person was thinking of taking their life, we could back up that in our contract we had outlined that we would break confidentiality. Then we have a factual basis for sharing that information. It's defendable decision-making. Rory, what else do we need to know about this?
I think that with very serious letters, if you have the time, and in some cases, I've written letters very quickly because in some cases there was clear and present danger. It's one for supervision. You know, if you've got the time, if you're thinking of having to write a letter, discuss it with your supervisor because 2 heads are better than 1. And also, when we talk about Principle 7, duty to share information can be as important as a duty to protect patient confidentiality. That is the pivot of defensible decision-making. That's the principle where you might have to justify yourself. If you can evidence that you've not just thought of it yourself, but have taken a professional opinion from your supervisor, and both of you have come to the conclusion that sharing the information is important, that actually would weigh in your favour should there be any form of investigation, because you've shown that you've taken a second opinion. I think that's always a good thing. I think that sometimes we can get paralysed by data protection, and that's why it's really important for us to be very thoughtful about what information we're sharing, the importance of sharing it, and also, as I said earlier, to get that valuable second opinion, to be in a position where you're doing the very best for your client.
You mentioned the magic words there, data protection, and of course that comes into effect when you are filling in a professional document or writing a professional letter for a client, for a supervisee. If you're in the UK GDPR, General Data Protection Regulation, is the law that governs how data is captured, stored, and shared. You will be gaining informed consent at the beginning of the journey with a client, letting them know where and how their data is stored and where it may be shared. And this is an interesting one, because when we're speaking about GDPR, a in-person, face-to-face therapist who works in a room with clients, who maybe keeps their written notes in a locked filing cabinet, may not have to register with the ICO, the Information Commissioner's Office in the UK, but check anyway. I'm not saying you don't. You need to check anyway for your own practice. But here's the thing. What happens when that client needs you to write them a professional letter, and you open your laptop and you open MS Word or a writing thing, and you write it, and then you pop it in an email and send it? You're processing data right there. So as soon as we're engaging in forms, emails, sending and writing and electronic storage, GDPR does come into effect. Always check with the ICO to make sure on that one. Rory, you're onto them on a regular basis with the ICO, because in Counselling Tutor, of course, we collect, store and manage data. And Rory never guesses. He asks, why defendable decision-making on this date? I phoned the ICO. I spoke to this person. This is what they said. Therefore, I did this. It is documented. Any final thoughts, Rory?
Yes, don't be frightened of writing letters to professionals. If it's the first time, take supervision, take an opinion. It's not unusual at all to work in a multidisciplinary way with other professionals. If you're writing a letter on behalf of a client and the client's asked you, then it's good practice to show what you're going to send and get them to agree. You could send it on an email or maybe a text, and then they could say, yes, I'm happy to send that, and then send it, put it with your notes. Any bit of information, any client contact, you put that with your notes and store it, because professional bodies will ask for your notes, communication with the client. So it's just to protect yourself. It really is. Also, to make sure you're doing the very best for your client, because as we've seen in the past, professionals have been a bit wary of sharing information, and in some cases, the outcome has been quite tragic.
Thank you, Rory. A really important topic, and interesting how deep we delved into it. And that is, of course, guidance on writing letters